stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do the making for time that I've lost. Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed them payments on purpose. Cause you see I failed and I'm hurting. Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, When Must State Courts Hear Federal Claims? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now as you all know, yesterday I made a video titled Federal Rules of Procedures Are Persuasive Authority. Okay, so if you haven't watched that video, then pause this video, click on the link in the description box to check out that video, okay? But for those who did watch the video, you all know that in that video, I addressed the situation that another channel put up, you know, basically trying to discredit the information that I put out. All right. So that same channel made a video stating that state courts must hear federal claims, which totally changed the whole subject of what we was talking about. But like I stated, you know, at least we are keeping it on the subject matter at hand, which is child support. You know, and believe it or not, I actually respect that, because that's what I want. I want us to keep everything dealing with the subject matter at hand, which is what? The law that we all are dealing with, because this way we all get better understanding of the law. Okay, so only thing that we must do now is grow up. You know, all the channels that's been going at it, we all need to grow up, man, to be honest. Like all this name calling and stuff like that, they're just keeping on the child support and the laws at hand. Okay, because if someone is putting out wrong information and someone else believes that information is wrong, we shouldn't have to, you know, call them names and stuff like that. You know, even myself, I'm guilty of that as well. Okay, so for here on out, you know, I'm gonna try not to, if I could, you know, just keep it on topic, man. You know, and just deal with more teaching and better education for everybody can get better understanding of what's going on. All right, instead of wasting time on a bunch of nonsense like what's been going on lately. Okay, but now, so basically, this is going to be a quick video in response to that channel that made the video. Even in that video, he was still doing name calling. But like I stated before, sometimes you got to lead by example. So in this video, I'm not going to name call or anything. I'm just going to stick to the facts and let you all make the decisions in the end on, you know, what was right and what was wrong. And that's all one can do, okay? So now, as you all can see on the screen, I'm coming from a book, right? I got it highlighted and everything else so you all can see what's going on with this information. All right. So we're going to pick this up at the top where it states F, application of federal law in state courts. All right. So let's pick it up right there. Subsection 1523, state courts must hear federal claims if they have what? Appropriate jurisdiction under state law. So that's your answer to the question right there. A state court can hear federal claims, but that state court must what? Have appropriate jurisdiction under state law. Meaning that they must be what? They must be a state law in accordance with the federal law in order for the state court to make a ruling on that federal issue. Okay? So let's proceed forward. It states, state courts have concurrent jurisdiction over claims arising under federal law unless the Constitution, federal statutes, or case law vest exclusive jurisdiction in the federal courts. So you all hear that. So state courts do not have to hear all federal claims. It's certain claims that they can hear, okay? And these claims that they can hear must be identical to the state law. All right. So when I tell you all to bring your claim in state court instead of going to federal court, why? Because state court have jurisdiction to make these same rules or to make the proper ruling. But everyone wants you all to stop what y'all doing and running in the federal court. Okay, so this information right here is still stating everything that I've been telling you guys to do from the beginning. It's to argue your facts in state court. And it's just that simple. But let's continue. It states, state court must hear federal law claims over which they have concurrent jurisdiction when state courts have jurisdiction to hear similar state law claims. Again, so both state law and federal law must be what? Concurrent with one another in order for the state court to hear it. Certain jurisdictional methods or certain jurisdictional rules or certain jurisdictional federal codes and laws that the state does not govern, they cannot make rulings on those cases. Okay, they must send those cases to where? Federal court in the proper jurisdiction. But let's continue. Federal law is enforceable in state courts because the Supremacy Clause makes federal law the supreme law of the land, which is true. That's why I tell you all again to always, what? Fight in state court. But let's continue. And charges state courts with a coordinate responsibility to enforce it, which is true. So everything I've been telling you guys is right here on the screen. Okay? So now that the individual pointed that out, he should further understand why I tell him to face these people head on in state court, not federal. Okay? But let's continue. A state violates the Supremacy Clause if it refuses to entertain a, now let's go to the next page, category of federal claims. When the court entertains similar state law actions against state defendants. For example, in Tester versus Kate. Okay, so you all can read this portion right here or the remaining paragraph. I'm going to proceed forward. But basically, in that case, Tester versus Kate, the state court declined to hear the case because it was a federal claim brought to it. But the federal claim is similar to a state claim that can be brought in state court. So it's a similar state law that's dealing with the same federal claims that was brought in that state court. So the state should have heard that claim. Okay? But let's continue. It states right here, states have the power to establish the structure and jurisdiction of their courts. Federal courts may not compel a state court to entertain a claim over which the state court has no jurisdiction under state law. Okay? So again, state law just can't hear all federal claims or just hear claims that they do not have jurisdiction over. Okay? And it's just that simple. But that individual on that channel made everyone believe as though state courts must hear all federal claims, which is far from the truth. But let's continue. Moreover, states are not required to create a court of competent jurisdiction to hear a case in which the federal claim is presented. However, a state rule may deprive a state court of jurisdiction to entertain a federal claim only if the rule really is a jurisdictional rule. You see what I mean? Let's continue. A state court may not justify its refusal to entertain a federal claim simply by characterizing a rule as jurisdictional. Okay, so remember, we went over what? The federal rules are what? Considered to be what? Persuasive authority. Okay, but let's continue. It states a rule is jurisdictional only if it deals with courts' power over the litigants and its competence over the subject matter, which is true. But let's continue. A state jurisdictional rule may not discriminate against federal actions. In Magnet versus St. Louis and San Francisco Railway Code, a state court interpreted a state statute to permit suits against foreign corporations for injuries in another state, but to prohibit suits on federal actions under the same circumstances. Thus, the state court refused to exercise jurisdiction over a Federal Employer Liability Act, FELA, action against a foreign corporation for an injury suffered in another state. The Supreme Court held that the Constitution prohibits state courts of general jurisdiction from refusing to exercise jurisdiction solely because a suit is brought under federal law. Because the state courts have general jurisdiction of personal injuries actions, the refusal to hear the FELA action constitutes discrimination against rights arising under federal laws in violation of what? The Supremacy Clause. But let's continue. The Supremacy Clause prohibits states courts from refusing to apply. Let's go to the next page. Federal law because of disagreement with its content. In Mudayo versus New York, New Haven, and Hoffa Railroad, for example, the state courts declined to recognize FELA actions, finding that FELA was against state policy and that application of federal law was inconvenient and confusing. The Supreme Court held that FELA may be enforced of right in state courts when their jurisdiction is adequate to the occasion. The Supreme Court found that the court's jurisdiction was adequate to the occasion because state courts was a court of general jurisdiction with connivance over wrongful death actions. So again, this will also bring you back to what? Those 1983 federal lawsuits. So I tell you guys to file your claims in state court. Why? Because we know that domestic relation issues, which is also family issues, are governed in state court. State court has sole jurisdiction over those matters. So the federal court will not make a ruling on them. They will simply dismiss the case for failure to state a claim and send you back to where? Back to the family court. But let's continue. Subsection 15.24. State courts may refuse jurisdiction over federal claims under neutral state procedural rules. Let's continue, guys. It states, states may apply their own neutral procedural rules to federal claims, unless federal law preempts those rules because application of the state rules would defeat federal substantive rights. Let's continue. A state court may refuse jurisdiction over a federal claim because of a neutral state rule regarding courts administrations. In 3 cases, the Supreme Court has upheld a state court's dismissal of a federal claim based on a state procedural rule. In Douglas versus New York, New Haven, and Hoffa Railroad, the court upheld the dismissal of a FELA action under a state statute that permitted dismissal of both federal and state claims when neither the plaintiff nor defendant was a former state resident. In Her versus Picarian, a city court denied jurisdiction over a FELA action because the action arose outside of its territorial jurisdiction, although the state court was not free to. Okay, guys, so that's all I'm going to do for today. Like I stated before, you got to get this right wisdom, this right knowledge, this right understanding, okay? So, study to show thyself approved, like I always say. Okay? I cannot stress this enough. Always study to show thyself approved. Like I stated before, certain cases, a state court must rule on federal issues. That's why I tell you all to bring your claims into what? State court. And it's just that simple. Okay? So for the individual that made that channel, thank you. Because everything you said, I've been telling people to say for the longest time. But you also misread it a lot because you read into it wrong, because not all federal claims can be brought in state court, or not all federal law can be heard in state court. Only the federal law that's incohesive or similar to the state law, okay? So that federal law must be similar to the state law in order for the state to rule on it, okay? So if someone wants to bring a claim against the state in federal court for, again, domestic relation issues, we know the federal court's going to dismiss the case because federal courts cannot hear state court domestic relation issues. They must be heard in court. So now if you want to sue the state for domestic relation issue, then you have to sue the state in the state. And it's just that simple. And we just read that here on the documents. So again, I'd like to thank you all for watching. That's all I'm going to do for today. You all be blessed. Like, share, and subscribe. Don't forget to hit that notification button, man. You know, be a part of history, man. Get this good information. So again, with that being said, guys, I say shalom.